everyone. Um, Let me keep my remarks short because I know there are a lot of speakers following me. I'd like to first start by thanking Dr. Agarwal and the GIPC team for organizing this conference. I've enjoyed every single year that I've been here, and I've learned a lot, met a lot of people, made a lot of friends, and most importantly, every year it feels like this conference is getting tighter and better, and I expect the same this year. So I'm really looking forward to, as Dr. Agarwal said, sitting in these sessions and learning from all of you. In my remarks until about a couple weeks ago, I was prepared to come up here and kind of talk about how the U.S. patent system is failing the patent owners, kind of decry the U.S. patent system, how justice is really hard to obtain these days for U.S. patent owners, how all three branches of the U.S. government, be it the executive branch with the President's office and all the administrative agencies under the President's office, such as the PTO and the PTAB, how they're failing the patent owners, and how the legislative branch, specifically the Congress, with their constant threats to quote-unquote reform patent laws so that they become more and more anti-patent owner, how that's threatening the rights, and how the courts, they're threatening rights by the way they apply Section 101 of the U.S. patent law and really shrinking what is patentable, and also some of the cases where they've really made it difficult for us patent practitioners to really value the worth of patents and patent portfolios. So that was going to be my speech, but I am, an optimist by nature, even though my wife probably wouldn't agree with that, but I am an optimist. So I want to look on the bright side at the start of this conference. And I think, 2015, from the middle of 2015 to 2016, I think there is some silver lining. And I think that's reflective of what's happened kind of throughout. If you look throughout U.S. history, I think you will see kind of the pendulum swing from a regime that is very lenient towards granting patents to a regime that is pretty stringent. If you look at just the past 75 years, without going through the entire U.S. history, if you look at just the past 75 years, after World War II, maybe during and a little bit after World War II, was a period of great innovation in the United States. And the sentiment was that patent owners were getting sort of a free ride because patents were being granted pretty easily. So what did the Congress do? Congress enacted the Patent Law of 1952, where they codified the obviousness requirement, and that made it a little difficult, probably a lot difficult, for patent owners to get their patents issued, because now the Patent Office was rejecting them based on this newly enacted obviousness requirement. And then the pendulum swung again, towards pro-patent in the 70s and so forth. And it culminated in Congress creating the Federal Circuit, which was a very pro-patentee court, at least initially, where they allowed for software to be patented, where they allowed for business methods to be patented. And that continued probably, I would say, until 2006, when Congress once again started wanting to reform patent law in view of the threat of these so-called patent trolls. And then that's when the Supreme Court started taking great interest in patent law as well. And 2006 was the first year of a landmark decision, the eBay decision, where where the Supreme Court essentially took away the right to get a preliminary injunction. They severely curtailed the exclusionary right that exists in a patent. And that just started the trend. Then you had KSR, and then you had Myriad, and you had Mayo, and Alice. I mean, it just kind of goes down the line. And I would say probably 2014, when some of these AIA enacted IPR decisions started coming down. 2014 was a pretty dark year for a patent owner. But I think things started to change sometime in 2015, and 2016 was, I think, a relatively good year. So I think the pendulum is starting to swing back. It's certainly not all the way back to the patent owner side, but I think we are starting to get there. I mean, in 2016, We had Congress criticize the PTAB, and they called it the killing field of patents. There is a recognition that the PTAB has somehow overstepped what their mandate is, and I think the Federal Circuit is doing the same thing by reversing some of the PTAB decisions. The Supreme Court, through some of its decisions, has made it easier to prove indirect infringement, has made it easier to show willful infringement. So some of these decisions are coming, and they're swinging the tide back towards the patent owner side. So why go through all this history? Well, I go through it just to make the point that conferences such as these are really important in this sort of fight against safeguarding patent rights. The exchanges of information that take place in a conference like this is really important to identify some of the gaps that exist, meaning the areas in which patent protection in the U.S. can be sought and obtained. And another reason conferences such as these are important is, patent law these days, and especially the field of patent monetization, is pretty global in nature. I mean, it's pretty commonplace now for patent owners to not just look at the U.S. to maximize the value of the patent portfolio that they own, but also look globally. I mean, they look at Europe, they look at China, and being at a conference such as this, which is very global in nature, allows U.S. practitioners like myself to understand the trends that are taking place in other markets, so that I can then go back home and advance my clients in a more informed way. So having said that, I will stop now and turn the podium over to my next speaker, but thank you very much for your time, and I look forward to sitting in many of the sessions and learning from a lot of you. Thank you very much.